That's a U.S. Bank Trust as a trustee for Velocity versus Joe Madrid and others. Do I have someone here on behalf of U.S. Bank?
Yes, Trevor Scholes here on behalf of the plaintiff.
Good afternoon, Mr. Scholes.
Good afternoon.
And do I have someone here on behalf of the defendant, Joe Madrid?
Yes.
Good afternoon, Mr. Madrid. Thank you for being here.
Hmm?
All right, and Mr. Scholes, why is this case being filed? Or why was it?
So this is a post-foreclosure eviction. The plaintiff purchased the property at a foreclosure sale on July 1st of 2025 for $225,000. A 90-day notice to vacate was sent certified mail September 24th, 2025. And plaintiff is only seeking possession. However, there's a lease that appears to be a legitimate lease, and it's not set to expire until September 30th of 2026. We have not been able to verify that Mr. Madrid has been making rent payments, but we also haven't been able to verify that he hasn't. So this is just kind of a weird one. We've sent requests to get proof of that. So I'm not sure if Mr. Madrid can show statements or anything that, because if he's been paying his rent, then he's not in violation of his lease, and therefore we have to allow him to stay and finish out his lease term.
So just so I this is a strange one here, Mr. Scholes.
Yeah.
Property
Yeah,
got foreclosed. Mr. Madrid was not foreclosed upon. He has an independent lease. So
Correct.
he's our third-party purchaser for value. Okay.
Correct.
All right. Do you know who leased it to Mr. Madrid?
Yeah, it's MAG Construction, MAG. We requested this information from them. They did not provide it to us. And of course, we couldn't force them to. So we don't know if he was paying rent to them or not. So yeah, it's just kind of a weird one. We just haven't been able to confirm. So I thought maybe Mr. Madrid could shed some light on that.
With that?
Mr. Madrid, you're not required. I'm just sort of thinking this through.
Oh, okay.
That's a weird situation.
Yeah.
Yeah, it's super weird because it's like a post-foreclosure eviction, but
Yeah.
could potentially be like non-rent paid. So it's an odd one.
Because the bank has title, so you have standing. It's just what's the cause of action?
Right.
You
Well,
don't, because you're not y'all weren't a party to the lease.
correct.
But you were bound by it because it runs with it. Mr. Madrid had nothing to do with it. Mr. Madrid, I'm sorry, we're kind of talking out loud here legally. I'm thinking it through, right? Like you're what's considered under the law right now in the world of that. You're like an innocent third party, right? You were not the original holder of the land. It sounds like through no fault of your own, someone leased it to you. You've been in that lease. So Mr. Scholl's position is that they don't really know if you're in good compliance with the lease or not because they were not the lessor to you. They bought the land through foreclosure, and then it is the rule in foreclosure that if there is a lease existing, it runs with the new title owner. So Mr. Scholl's client, essentially, they inherited a lease, but they weren't a party to it, so they don't have a copy of it. That's a
Yeah. And
Mr.
I
Scholl,
mean,
have you seen the lease?
I have seen the lease.
And you said it's through 2026 through what month?
Through September, it expires September 30th of 2026.
Melted. You emailed it to him.
And under the lease, there's a requirement to pay rent.
Yes, of $2,200.
I'm just curious, Mr. Scholes, Mr. Madrid, you don't have to respond to this. Your client's not entitled to the money because they're not a party to that contract.
Right. Well,
So
yeah. I
here's
mean,
my question. Here's my question. Even if it was true that the defendant, and I don't know that, let's just say that it's true the defendant hasn't paid the rent. Do y'all have standing to sue for a breach that's not your lease? Wouldn't that be MAG contractor's claim?
Well, we wouldn't have. Well, so we're not seeking back rent, right? So
right, but you're seeking possession upon a lease that's been breached.
Correct.
Can you declare that?
Well, my argument would be that that U.S. Bank is in privity of the contract by assuming the lease whenever they purchase the property, right? So they stand in the shoes, which subrogation is really the argument I'd use, that they now stand in the shoes of the original the original landlord. However, I'm really not trying to argue that today. I would really just like for Mr. Madrid to say hey, I've been paying rent or not. I think really the best case scenario here is get Mr. Madrid to, we would like to do a new lease. We don't necessarily want to evict, but because if he's like, you're right, if he's breached that, we don't necessarily have, well, at least not in a forcible detainer action, there's no jurisdiction, nor do we really have standing to argue that he breached the lease. I agree with you there.
Do
But
y'all want to, I'm curious, because Mr. Scholes, Mr. Madrid, court's not trying to interfere with y'all doing your jobs and your business, right? We can give y'all a private moment if y'all want to talk to each other completely outside of the purview of the court.
that would be great. Yeah.
Mr. Madrid, you don't have to do that. Would you at all be interested in talking to Mr. Scholes in a private room about kind of the strangeness of the situation y'all got?
Yes, I will.
Why don't we do that, Stephanie? Give my clerk a moment. She's doing a wonderful job. This is, I think, her third solo docket. And we all know the fun of Zoom and breakout rooms, but let's give y'all of that. And how about, we'll just let y'all go into a session. I'll do some private work here. When you're done, let me know. If you need to proceed, we can. But yeah, that's a funny.
Yeah, it's
That's
an
a
odd
funny one.
situation. Yeah.
It's a very odd situation. I'll also give y'all this. If parties end up coming back, let's say y'all want to take a little more time, we could grant a continuance here, Mr. Scholes, just because of the situation that's going on. So let's get y'all a room, let y'all discuss some things. Come back, let me know what y'all come to, because that's why I love doing this job. You get 99 cases that fall within a very, like, I ask 6 questions, we get there, and then I get one, and I'm like, wait, you literally, every question is a different answer. Huh.
Yeah. Yeah, it's
That's a
awesome
law
for me
school
too.
question right there. That's
Yeah.
you got
Yeah,
some
it's cool
fun
for
ones.
me too, right? It makes work fun for, like, this is where, you practice creative solutions.
I'm kind of like, this is almost like trying to feel like function law back in the day when it was if, but, bore, then, and you were literally
Yeah,
back and forth
but
between
it's bad whenever there's like no case law, right, for guidance. So
we occasionally get justice cases that go up to the Court of Appeals and to the Supreme Court. It's always pretty shocking. Like, really? And I'm like,
yeah.
listen, we
Yeah,
had a
I'm not sure
novel situation.
I'm not sure we're trying to litigate this one that hard.
No, but huh. All right. There we go.
All right.
So you guys join that. That's completely private. It's not on YouTube at all. We'll just be in recess. When we all come back in, we'll come back.
All right, thank you, Your Honor.
Okay, absolutely. Stephanie, we'll just consider this a recess so we can turn our cameras off and we'll just hang out on Zoom and let them come back. Thank you. Welcome back, Mr. Scholes. We'll give Mr. Madrid a moment. He may still be in the breakout room. Well,
It looks like he left.
Yeah, he might not join. I told him we were gonna, I think we're just gonna non-suit this. He's got a mother with dementia in that house, and I don't see any reason to not let him finish out his lease. So we'll just try to work something out outside of the court.
Mr. Scholes, that seems very, very reasonable, given especially all the kind of the strangeness with that. So thank you. Really appreciate that.
Thank you,
All right.
Your Honor.
Have a great afternoon. We appreciate it.
too.
And then our final matter, 26247, was also, that's a DWAP. We didn't have anyone show up for that one, Stephanie.
Okay, perfect.
Have a good afternoon. Thank you.
Thank you, you too.
Ms. Garza, tell me why this case was filed.
Yeah, so we're here for payment of rent. We are missing February's and then obviously the prorated for today in March.
How much is the monthly rent?
It's gonna be $17.29. And
17.
then the prorated for today or for March till today is $167.32.
Is there any subsidy on that 1729 or is all of it owed by the defendant?
All of them is gonna be, I'm sorry, say that again.
Is there any subsidy? Does the landlord directly receive payment from the government on the rent?
Oh, no.
Okay,
Sorry,
so
I just
defendant owns all of it. All right. Was your property under the Federal CARES Act?
No, ma'am.
And was this the first time in February that the defendant was late on the rent?
In February, yes, but not in like the term that he has been here. We also sent him a notice to pay rent or vacate on 2/5, and then we also sent it via certified mail too. So via email and mail.
Okay. So you sent him a notice to pay or vacate February 5th, and you both mailed and emailed that?
Yes, ma'am.
Okay, that's fine. Good afternoon, sir. Thank you for being with us. So Mr. Merritt, my first question is the monthly rent correct? Is it $1,729?
It is.
Okay.
Yes.
And then Ms. Garza says this is a recent situation, but is it correct that February and March rent remains unpaid?
No,
Well,
Okay.
February, March, yes, yes.
Okay, so February and March remain unpaid.
To this point, I was hoping to get to the amount so I could pay it and stay and make this go away, but I guess that's not why we're here. So this was a hearing.
Well, Mr. Merritt, it is the hearing, but the burden of proof for the landlord is pretty minimal here. So if they establish that there's a lease, and there's no denying that, you've acknowledged that there's a lease.
Yeah.
If the rent is due on the first and it has not been paid, that is literally all the landlord has to prove to be able to evict you. Even if you today gave them all the money, plus interest and extra payments, the landlord has still proven their case and can evict you.
Okay.
Okay. Now, that doesn't mean you can't still negotiate or reach out to the Bell South Lamar. I will give both parties some information. Let me conclude the case, and then I'll give Mr. Marriott you information and Ms. Garza, and then that may give y'all some extra stuff that you may wish to do. Okay. All right. So the judgment would be for February and March, and for March you only want 167. So the amount that I'd get would be 1896. So that would be the judgment for the plaintiff. Back rent of $1,896, and then the cost of court. Either party can appeal. It would be equal to 1 month of rent. So that appeal bond would be $1,729. Now, Mr. Merritt, the number that I've just awarded, the 1,896, that's just February, the whole month, no late fees, and 3 days of March rent. Per the lease, you probably owe the whole rent already for March, right? So the number that the landlord will give you will quite likely would be higher. It would be both months of rent, and they might include late fees, utilities, anything else the lease says you owe. The law in Texas says that in an eviction, the landlord is here first to get back possession of the property and then back rent. And so they can only seek actual rent, which is why the landlord only asked me for 3 days and they didn't put any late fees in it. So that's to explain the difference between the judgment amount and what the landlord will likely give you as a bill, right? Now, you have 5 days to appeal my decision before this judgment of 1896 becomes final. If in that 5 days, you reach out to the landlord and y'all negotiate. Sometimes I have landlords say, listen, if they just give me all the money, I'm happy to set this aside or vacate the eviction. But legally, they do not have to do that, Mr. Merritt. You could offer all the money and the landlord legally can say, no, you breached the lease, you didn't pay it on time. I wish to keep it as it is, right? What I'll just say, Ms. Garza, and you've probably been here for the docket and heard this, if y'all come to some resolution and you wish as the plaintiff to set it aside, let me know by the end of the 5th day and we still have that authority. After that, I'm out of luck. I can't do anything for y'all. Okay. You can also appeal. If you appeal, then this judgment is void and it goes up to the next court, and then you'll kind of get the same thing again with a different judge. All right. Mr. Merritt, does that give some information?
Yep, that's good.
All right. Again, then all parties are excused. You have at least 5 days to appeal, or if y'all come to some other resolution, notify the court of that.
Perfect. Thank you.
All right. Thank y'all very much. Y'all have a lovely afternoon, or
Okay.
have a better afternoon.
Right.
All right. Thank you. Ms. Den, why is this eviction filed?
Non-payment of rent,
All right. What's the month? Is there monthly rent? And if so, how much?
September, and then say hasn't paid since September, 1099 is the rent.
All right. 1099, and it remains unpaid since September.
Yes.
Is there any subsidy from the government?
No.
All right. When was the notice to vacate given?
This one was given 2/5/226.
Was that a 3-day or a 24-hour notice?
It's a 3-day.
Okay.
They're not, yeah.
And then was that just a vacate, or was that a pay or vacate? Well, it doesn't really
It's a-
matter because he'd already been late since
And
September.
I already gave them another one, yeah.
Yep, you're totally fine. Okay. All right, then. Good afternoon, Mr. Garcia.
Hello.
Thank you for being here. Ms. Dens here, she represents the landlord Cherry Hill. And she said this, as I often hear, these cases are a financial situation, which is no fun for anyone, but it does happen. So my first question, Mr. Garcia, is the monthly rent amount correct? Is it $1,099?
Correct.
Okay. And then she says rent remains unpaid since September. Is that also accurate?
Yes, ma'am.
All right, well, Mr. Garcia, with that information, the landlord wins their case today. But certainly this is a chance. If you have questions, I want to give you numbers, deadlines. This is your opportunity. Immediately, do you have any questions that you are ready or you want to ask?
Yeah, what is the final day I have to be out of there?
Okay, Mr. Garcia, that's a great question. And people love lawyers and judges because I can't tell you the date. I can tell you how to figure it out. Isn't this a fun one?
Okay.
Okay, Mr. Garcia, this is how it works. If you look at your calendar, tomorrow is day 1. You have 5 days. If
Okay.
when you count forward on the calendar, 1, 2, 3, 4, 5. If the 5th day happens to fall on a weekend, you get till the next day. If
Okay,
it
so
falls
it
on a
would,
day that is a national holiday or a state holiday, and I don't know what next week is, but there might be some sort of a holiday.
it's daylight savings on Sunday.
No, that's not one of them. It's gotta be
Okay.
like, LBJ Day or Texas
Okay.
Independence Day or the 4th of July, a day that the business, that, the state is taking a holiday.
Okay,
Yeah, I don't see any next week. If the 5th day falls on a weekend or a holiday, you get till the next day. So I'm not allowed to help you figure out if it's March, this or that. I can only tell you that it's at least 5 days. And so, Mr. Garcia, when you're done today with us, if you want to know exactly what date you have, you can call any of those legal aid phone numbers on our website and say, hey, I got evicted today. What's my deadline? And they will literally look at the calendar and tell you. But as
okay,
the judge, I'm not allowed to.
okay, that sounds good.
Okay. All right. Let me give you some other information though that you would want to have for that. So I get 1099 is the month. Okay. So September, October, November, December, January. I got 5 months at the full amount. And February, 6 months. September, October, November, December, January, February. So 6 at the full rate of 1099 is 65.94. And then for March, there are 31 days. So I'm getting $35 a day. We got 3 days, plus 106. So 106 plus the 65.94. Total, oh, is that right? Oh, it is. The total judgment that I calculate is $6,700, flat and even. Okay.
Okay.
So Mr. Garcia, the judgment is for 6,700. Either party can appeal. For appeal, the appeal bond will be twice the monthly rent. So that's $21.98. Mr. Garcia, if in the next 5 days you wish to appeal, you could either pay the appeal bond or file an affidavit of inability. And then if you wish to stay in the apartment while the case is going to be transferred to a new court, you have to pay 1099 and you give that to us, not the landlord. We give you an exact deadline when the money comes in, okay?
Okay,
If you don't do any of that, on day 6, the landlord can seek what's known as the writ of possession. It's issued by the court, and then the constable notifies you that if you haven't left, they're going to oversee the landlord removing you and your items. Okay?
okay,
You got
understood.
at least 5 more days beginning tomorrow. All right. Good luck to everyone then. If there's no other questions, all parties are excused.
Okay, thank you, Your Honor.
Thank you very much. Good luck to everyone.